Hey all, welcome back to another week of KNR 382. Our topic this week is on contract law, and as you can imagine, there's a lot here in regards to legal issues that we want to cover. Really, we could spend several weeks on this topic, but in the interest of time, we're going to condense it into 1 week. So keep in mind that we're really just covering the highlights here. If this is a particular topic that you're more interested in, I'd be more than happy to share some additional readings on the topic. And, for the scope and purposes of this class, what we really want to highlight are, some of the main legal principles related to contracts. We're going to look at the requirements for a legal contract. We'll identify some of the elements needed for a breach of contract case. And then finally, we'll take kind of a big picture view at some of the major antitrust and labor laws that have been passed that have really created the current landscape for contract law. So that is our plan today. Keep in mind that, at some point in your career, you may have already faced this, you're going to have to either sign a contract, agree to a contract, or develop a contract for your job or your career, first and foremost, beginning with your employment contract. So this is something that's important for KNR practitioners to be aware of. Okay, so you can see here we've got a quick definition of the word contract. You can see it's an agreement entered into voluntarily by two parties or more with the intention of creating a legal obligation. When we move on to the next slide, we'll identify the exact legal requirements for a valid contract, but this gives you an idea of the terminology. Now, normally if this were an in-class session, I would ask those in the room to give examples of contracts that are commonly used in KNR setting. Obviously, we've already looked at one of these examples this semester, and that's a waiver when we were looking in our negligence unit. So beyond a waiver, there are many different types of contracts that you might use in your career as a KNR practitioner. Anything from rental agreements, vendor contracts, facility agreements, sponsorship agreements. You could go on and on here. I think hopefully this illustrates that contracts are very common in our field, and because of that, it's really important that you as a practitioner, one, understand what is required for a legal contract to exist, but also making sure that you prevent any kind of legal fallout from a contract you create so that you're protecting yourself throughout the life of that contract. So, essentially what I want to move on and look at now are these legal requirements for a valid contract. So, if you think back to our conversation on waivers much earlier in the semester, we got to this a little bit. We identified some of the key components of a waiver, and some of those components included some things you're seeing here. But keep in mind, these are more general requirements in order for a contract to be deemed valid in the eyes of a court. So this is just a very basic way for us of saying that, these things are necessary in order for the court to find a contract legal. Keep in mind, actual contract disputes tend to be very messy and oftentimes go beyond what we'll talk about in this setting, but I think it's important for you to be aware of this baseline when you're developing contracts or getting into a contract agreement. Okay, so our 4 legal requirements here are: 1, consideration. This concept of consideration basically just means that in order for a contract to be legal, there has to be some kind of exchange in value, right? Both parties have to be receiving something through this contract. Something of value has to be exchanged. This is typically not a problem in our field, right? Typically, any kind of contract you're getting into, there is some kind of exchange for value, right? Some kind of monetary value provided for goods, services, programs, you name it. So consideration is not typically an issue in our field unless you're dealing with a situation where services or goods are being provided at no cost. So for example, say a nonprofit wants to utilize your facility at the recreation organization you work at, and you want to provide that space. It's still important in those situations, if you want to have a valid contract, for there to be some exchange of value. So this is where you see what we call dollar contracts, which may sound crazy, but this actually occurs fairly regularly in our field. So that in order for those user contracts to be valid, the company will actually just charge a single dollar to that nonprofit so that they can show there's consideration, right? They haven't obviously charged them the full fee of using the space, but they can show an exchange of value has occurred. So again, that's kind of a side issue and isn't that common, only if you're going to be providing a service or good at no cost. But generally, the contracts we deal with, there is that exchange of value. All right, capacity. When we say capacity, we're referring to the mental capacity of the folks that are entering into the agreement. So basically, in order for a contract to be valid, both parties or all parties have to have the mental capacity to enter into that agreement. They have to know and understand what it is they're agreeing to. When we think about what can impact capacity, we talked about this a little bit in our negligence unit when we looked at waivers, right? We talked about how judges generally have said minors do not have the mental capacity to enter into or agree to a contract. So age is certainly something that impacts capacity. Mental health is something that impacts capacity and someone's understanding of what they're getting into. Alcohol and drugs can certainly impact someone's capacity and whether or not they know what they're agreeing to at the time. So all of those things can inhibit capacity or someone's ability to understand what it is they're agreeing to. So that's an important component of a legal contract. This third requirement is pretty straightforward. In order for a contract to be valid, the terms of that contract have to be over legal concepts, right? You can't agree to something illegal in a contract and then have it be upheld in court. So the terms and conditions of the contract have to be legal. Finally, in order for there to be a legal contract or valid contract, there has to be agreement, meaning that the parties involved have to agree on the terms of the contract. They can do that through writing, actually signing their name on a contract. There are other situations where there may be simply a handshake agreement or an oral agreement. And we'll talk here on the next slide about whether or not that's acceptable, whether or not a verbal contract is acceptable. But just note that in order for a contract to be valid, there has to be agreement from both parties or all parties entering into that contract. Okay, so those are our 4 requirements for a valid contract. So anytime you find yourself putting together a contract or signing or agreeing to a contract, make sure that you review these requirements and make sure that you're fulfilling these requirements in that contract. Okay, so I mentioned on the last slide that this question about whether or not contracts have to be in writing. And the answer legally is no. A contract does not have to be in writing in order for it to be legal. So verbal contracts, handshake contracts where people agree over a handshake or just verbally are legal except in some situations, okay? So the UCC, or the Uniform Commercial Code, which dictates some of the legal requirements surrounding contracts, has determined that contracts that meet certain criteria have to be in writing in order for them to be legal. So you can see here there are basically these 3 different scenarios where a contract would have to be in writing. So this first one speaks for itself, right? A sale of goods over $500.
that exchange of value that's occurring is over $300 or sorry, $500. I don't know why I said 300. $500. In order for that contract to be legal, it would have to be in writing. So again, really any kind of exchange of value that occurs over $500, that contract would need to be in writing. Any kind of contract that involves sale or interest in land must be in writing. So if I'm in the process of selling my house and I want to sell by owner, that's fine. But in order for that contract to be considered legal, I would have to actually get that in writing, right? Again, any kind of contract that involves the interest in land or real estate. Finally, in order for certain contracts to be considered legal and be in writing, contracts that cannot be fully performed within 1 year also meet this requirement. So what does this mean? Well, basically, if a contract is long-term, meaning that the terms and conditions of that contract cannot be fulfilled within 1 calendar year, then it has to be in writing. So, for example, if a coach were to offer a 4-year athletic scholarship to a student athlete, in order for that to be legal, they would have to put that in writing to make it a legal contract. So they couldn't just promise them over the phone that they were going to make sure they had a 4-year scholarship, because that can't be performed within 1 year of time, right? So any contract involving terms and conditions that go beyond 1 year's time needs to be in writing. Okay, so keep that in mind. And when we think about the fact that certain contracts have to be in writing, we know that this is true because of this legal concept called statute of frauds, which essentially just says what I stated, right? That in order for certain contracts to be legal, they have to be in writing. And the UCC, or the Uniform Commercial Code, dictates the requirements there. So make sure that you're aware of those specific criteria. Now, just to give you my own input here, even though the court will accept verbal contracts in other cases, I strongly encourage you to get all of your contracts in writing. Simply for the reason that it will make things less complicated and messy down the road if there is some kind of dispute, right? If you clearly identify the terms via a Word document or some kind of written form, then you have that information and you can go back to it at some point, and it could be useful to you down the road if there is some kind of fallout or disagreement. So yes, the court says there are some situations where you must have contracts in writing. My recommendation is get all of your contracts in writing, and that's professional and personal, just for your own protection. Okay, so as we think about this topic of contract law, it's important that we identify that there are certain situations that come up where one party to a contract has been deceived, right? They've entered into an agreement because they've been deceived by the other party, and thus they would like to get out of that contract. So there are essentially two different concepts here that I want to discuss in terms of deceptive contract. Excuse me, I'm losing my voice. That deal with deceptive contracts. So fraud is the first, and you can see here based on our definition, fraud is essentially when someone has intentionally, deceptively provided a false statement or assertion of fact, which then induced another party to enter into a contract. Okay, so fraud is a very serious act. Because obviously you're looking at an intentional act here, someone's intentionally done to deceive another party in order to get them to enter into a contract, right? So if a high school athletic director, for instance, created a set of false pieces of information in order to induce a concessionaire to enter into an agreement with that high school, then that would be considered fraud, and the concessionaire would likely be able to prove that this is illegal in court. So where fraud is intentional, this other concept is misrepresentation, which, as you can see, is actually unintentional or an innocent false assertion of fact, which also induces another party to enter into a contract. So misrepresentation is also illegal, but it's not deemed to be quite as serious of an offense as fraud, given that you're looking at an unintentional or innocent false assertion. So if that same high school athletic director provided false information but did so unknowingly, then it would be considered misrepresentation and not fraud. So again, either is wrong and illegal, and either would give the other party the option of voiding their contract within a reasonable amount of time. Fraud likely allows there to be a lawsuit, while misrepresentation most likely leads to just a breach of contract and the parties walking away from one another. I'm going to post a story on RegieNet here of a fairly recent case involving fraud in our field. This case involved a class action lawsuit against 24 Hour Fitness after they increased rates on what they had termed lifetime membership contracts. So they had intentionally misled people into signing up for these contracts that stated, hey, this is a lifetime membership at this rate, and then over time actually increase those rates. So a group of members who had signed up for this plan got together and filed a class action suit over that, stating, essentially that this was fraud, that they provided this false information about the rates staying low, and did so intentionally in order to get them to enter into the contract. But yeah, I'll post that to RegieNet if you want to read more about it. Okay, so I want to talk briefly now about this concept of breach of contract. So again, essentially, breach of contract occurs when one party fails to perform the duties imposed under the contract. Okay, so keep in mind that, excuse me, in these cases of breach in contract, there are a number of things that can happen. Basically, the court, or the eyes of the court, will view the contracts in one of three ways. They'll either view them as valid, void, or voidable. So a contract is deemed valid if it's deemed legal and both parties are required to perform the obligations of it. So that's valid. If a contract's deemed void, then that means that the contract is thrown out and neither party needs to perform the obligations of that contract. Finally, if the court deems a contract to be voidable, they've determined that one side has the option to void or exit the contract. Okay, so typically a breach of contract case will end with one of these determinants, right? Either the contract is valid and all parties have to perform it, it's void, meaning it's essentially thrown out, or it's voidable, meaning that one party in the agreement has the ability to decide whether or not they want to void that contract. Keep in mind there are essentially two different categories of damages that can be awarded in a breach of contract case. Okay, on one hand, you have what's known as monetary damages, which we've talked about a lot in here, in reference to some of the other legal issues we've discussed. So monetary damage would require whichever party breached the contract to make a payment to the other party. That's pretty straightforward. There may be some cases, though, that require this other type of damage, which is known as specific performance. So specific performance is going to require an actual performance or delivery of terms, okay? Meaning that there are certain situations where a contract or the terms of a contract include something very specific, and by not providing or delivering that specific thing, the court might argue that instead of paying monetary damages, that party should actually provide the product or service that they promised through what we call specific performance. So you can imagine there are certain things where this might be the route that the court takes. If someone purchases tickets to a major sporting event that only happens once and the other party breaches their contract, that might be a situation where the court orders specific performance, right? Because it's a very unique one-time item. The same could be if someone purchases memorabilia, signed autographs, those sorts of things that are, very specific and unique items. Rather than requiring monetary damages, the court might say, hey, you have to actually provide and deliver this item that you promised. So there are some cases where you'll see specific performance, which is essentially the court telling the party that breached the contract, hey, you have to actually deliver on what you said you would. Okay, so that's a little bit about breach of contract. I want to shift now to looking at the elements of a breach of contract case. Keep in mind, burden of proof here is going to fall on the plaintiff. And you can see here there are essentially 4 elements that they would need to prove in order to prove that a breach of contract has occurred. So first and foremost, in order to be successful in one of these cases, the party or the plaintiff would have to actually show that there was a valid contract to begin with, right? So if we rewind back to one of our initial slides in this series, we identified those 4 requirements for a legal contract. So they would have to show at first that there was this valid contract that existed at some point in time. Pretty straightforward. They would have to be able to prove that they, as the plaintiff, performed what was specified by the contract. So basically, they held up their end of the deal, right? They had provided, whether it was some kind of monetary provision or a good or a service, they performed their side of the deal. The other side of that coin, and the third element here, is that they have to be able to show that the defendant failed to perform as specified by the contract. So they performed their side as the plaintiff, the defendant failed to uphold or perform their terms of the agreement. Again, fairly straightforward here. And then finally, in order to be successful in a breach of contract case, the plaintiff has to show that they suffered an economic loss as a result of that breach of contract. Okay, so somehow, as a result of the defendant not fulfilling their side of the deal, the plaintiff has now suffered some kind of economic loss. So we've seen this in other cases that we've looked at previously. This is really kind of our damages element, similar to what we looked at in negligence, right? So showing that some kind of loss has occurred. In this case, when we're dealing with contract law, that's typically some kind of economic or financial loss. So in order to be successful in a breach of contract case, the plaintiff would have to be able to show or prove each of these elements in court. And if they're able to do so, they would likely win the case, and then the court would determine the appropriate steps to move forward. Okay, so that's the end of our first half of our unit on contract law. So I'm going to pause and record the second half, which is just going to introduce some of the basic labor and antitrust laws that, again, really built a foundation in this country for the existing contract status that we live in today. So go ahead, and once you're done watching this one, go check out that other one. Thanks.